Thank you, Mark. Let me join you in welcoming you to Oxford on behalf of the Oxford Intellectual Property Research Centre. Let me thank Mark and all his colleagues from Indiana. I'm delighted. I've worked with Mark for many years on a personal level. I'm delighted that we're able to collaborate institutionally, both with the IP Centre and with the IP Centre at Indiana. There already are some strong bonds between Oxford and Bloomington, both with other places such as the Internet Institute, and even in the law faculty I have colleagues who teach regularly in Indiana. I'm delighted that we've managed to extend that bond to intellectual property. I hope this is first of many things that we're able to do together. Let me also thank the sponsors without which we couldn't put on this type of event and bring people from all over the world of the quality that you're going to hear over the next 2 days. So I'm very grateful both to McAndrews and to Microsoft for their support of this event. And let me add, in addition to the thanks that Mark extended to the folks from Indiana, also to the folks from Oxford from the IP Centre, Ellen Moylan and Jenny Hassan, who they aren't actually here at the moment. They're actually working very hard at the Law Faculty on Undergraduate Admissions Week, so they don't get the joy actually of listening to what they managed to produce, but their help has been invaluable. I'm particularly delighted that the topic of our first collaboration is design law. As Mark said, Mark and I have been interested in comparative design law, along with a good number of people here who I sort of think of as the design nerds around the world that we see each other at lots of events over the years. My fascination, and for those who are British practitioners and maybe European practitioners, some of this actually might echo, my interest in design, in fact my whole interest in intellectual property came from design law. Because I was a student at Glasgow at the time when, this is a while ago now, but the House of Lords, as it then was, handed down the British Leyland versus Armstrong decision in 1986, and I was taking, with a little but not a huge amount of enthusiasm, a class on copyright law. And this case struck me as absolutely crazy. And it embodies the attractions of design in so many ways. It was a case where we said, well, I understand why they reached that decision, but by God, did they have to reach it that way? And the complexity of design law became immediately apparent. I really need to know more about this subject. And so I got hooked on intellectual property law, largely through design. So I'm delighted that we're able to have this first collaboration work on the issue of design. Design attracts people for a number of different ways, and I thought I'd start with just a couple of quotes, which shows a couple of different ways in which you can approach it. And I hope we actually adopt the former, but I'll read the four and you'll see what I mean. The first one is from an American scholar, Jerry Reichman, who is another one of the design nerds. In fact, if you read Jerry's work from the late 1970s and early 1980s on comparative European design law, actually I think some of the best comparative design work you'll find anywhere. And Jerry says, industrial design has posed the intellectual property world's single most complicated puzzle. Judge Rich, also on that side of the Atlantic, said now 30 years ago, fabulous amounts of time and effort have been poured into solving the design protection problem with, to date, no legislative solution. Right. Well, those are probably real world views, but they're still sort of looking forward. It's a complicated puzzle. We haven't yet reached the answer. Right? On this side of the Atlantic, we are a little bit more cynical to some extent, at least on the British side, maybe not the European. So let me give you a couple of British quotes from the last couple of years. From Dyson Qualtex, from Lord Justice Jacob, who will be joining us later today and was on the bench yesterday in the Apple case, as you may or may not have seen coverage of, commenting on the British Unregistered Design Rights, section 213, said that it only has one merit. It is short. Otherwise, it is incomprehensible. All right, which is a little bit more trenchant, perhaps, than Jerry or Judge Rich were. Or Bill Cornish, now Emeritus Professor of Intellectual Property at Cambridge, who simply described design law as an absurd maze. All right, so we are a little bit more cynical, I think, on the British side, perhaps, of what position we have reached. But design is a strange mixture of immensely complex but fascinating intellectual puzzles and a history of an accumulated set of rights that can be quite complicated to navigate. But it should be evident, I think, just from the amount of activity in the last year alone, that design law is at the forefront of all of intellectual property debates. I mean, you could do an entire conference probably just on Apple and Samsung, looking at the amount of litigation around the world involving those companies. You can look at the legislative activity that's occurring in the United States, in the United Kingdom at the moment with consultation on design reform. You can look at what I think is the growing amount of interest throughout Europe and now getting ECJ attention on the European design legislation that's been in place for a decade. You can look at legislative interest in Asia, which we can hear a little bit about as well, on reforms of design. So design is obviously important. I suggest it's important to different constituencies for different reasons, and I hope we tackle, to some extent, all of these. First, it's extremely important for business as the sale of products and development of products becomes more design intensive, and as companies put more money into design, it's obviously a very important question as the extent to which they can get protection in return for that particular investment. So from the business perspective, design has become increasingly important. Not unrelated to that, of course, as it becomes important for clients, it becomes important for lawyers. And so as you can see in the Apple and Samsung litigation, the amount of contested treatment of design protection is actually something that is increasing, I think, in quite a steep curve around the world. And obviously that therefore makes it extremely important on the practitioner side. Connected to both those developments, therefore, result policymakers get involved, because if business is interested in these issues and lawyers are interested in these issues, then policymakers have to work out how to make the complexities that lawyers see less problematic and the business's interest more relevant. And so therefore we have a series of developments at the regional level, at the international level, and a variety of national level on the policymaking side. Scholars, I hope we are all interested as academics in design law for all of those reasons. It seems to me that we should be interested as scholars because it interests policymakers, because it interests practitioners, and because it's of relevance to businesses. But I'll suggest one final one, if this is a little bit maybe too indulgent from those of us from the academic side, but I hope it's not irrelevant to others as well, which is because design sits at the juncture of so many other intellectual property regimes, and because it forces us to think very hard about differences between art and utility, between function and aesthetics, it gives you a window into a lot of issues that actually pervade the entire intellectual property system. So what is the role of the registration? For example, should registrations be examined? Should they be unexamined? What work do categories do in intellectual property law? So for academics, there's a series of issues I hope that we'll look at as well. And I hope that all of these different perspectives are perspectives that we're going to cover over the course of the day and a half. So with that sort of somewhat, I hope, foundational introduction to the subject, let's turn to the first panel. As I'm delighted we have 4 speakers on the first panel. They're all going to speak for roughly 20 minutes. Then we will open the floor to questions. We don't have floor mics. The room is, I hope, of a sufficient size and acoustics that we actually can just have you speak and project when you're asking questions. Let me introduce the 4 speakers, and then I'll indicate the order in which they're going to speak, and then we'll proceed with the presentations and then question and answer. So first of all, to my right, Professor Estelle Derclay, who's Professor of Intellectual Property Law at Nottingham. I like to think occasionally that I'm cosmopolitan international in my academic background, but I can't match Estelle. Estelle has degrees from Belgium, the United States, and the United Kingdom, so I'm a little bit behind. So we're all just a little bit behind. Estelle has written in a number of areas, but I think what's particularly notable about Estelle's work is that she has always tackled what I think are the hard issues in intellectual property law, the stuff at the edges, databases, design rights, etc. So welcome, Estelle. Henning Hartwig, sorry, I'm jumping a little bit, so 2 over. Henning is a partner at Bardley Packenberg in Munich. And is involved in a large number of very significant litigation involving design rights. Henning also has a tremendous academic record, but I want to point out a particular contribution that Henning makes to for all of us, and that is his publication of case reports and publications of writings on design law. Making accessible, at least for those of us particularly who are not as linguistically adept as others, a range of design sources that otherwise would not be available. And I think that's immensely important to enhancing our understanding of design law. David Gurk, who's in between Estelle and Henning, is an attorney in the Office of Policy and External Affairs at USPTO. David actually also is a George Washington grad, along with Estelle. We have two GW alum on the panel. David was in practice previously at Banner Whitcock before joining the USPTO, and he has represented the United States both on domestic and international policy-making levels, and is also an author of publications with the ABA. Finally, at the end of the panel, although Paul's actually going to speak first, Paul Mayer, who I guess I technically should say you're still president of the Boards of Appeal at OHIM, but very soon to become first head of the new observatory, which will have a much expanded role in European intellectual property policy. Paul previously, before joining OHIM, was a very important figure at the Commission in the development of many of the early intellectual property instruments, some of which we are going to discuss today. So we have a very talented panel. I'm going to shut up and let them take over from now on. The order in which we're going to proceed, I hope with some degree of logic built into it, is Paul is going to speak first, followed by David, who set up the scene a little bit, and then we'll have Henning and Estelle will follow. Paul.